this video, we're going to be talking about corporations and LLCs for our highly tested issues MEE guide. First things first, let's talk about the frequency in which you can expect corporations and LLCs to be tested. Our frequency chart illustrates that corporations is tested on average a little over once a year. Our frequency chart also illustrates that corporations and LLCs is usually tested whenever agency and partnership isn't tested. Thus, your average bar exam tends to have an agency and partnership question or a corporations and LLCs question. Now, that doesn't mean that there aren't exceptions to this. Actually, the frequency chart would show you that there are instances in which an agency and partnership question as well as a corporations and LLCs question have appeared. But this is just something to keep in mind. So now that you're a little bit more familiar with the frequency in which corporations and LLCs is tested, there is something else that I want to point out. Many of the rules that you will learn for corporations are also applicable to LLCs. For example, if you learn the fiduciary duties that apply to directors and officers of a corporation, you can apply those same rules to the members of an LLC. And I want to point this out because it's very easy to get bogged down by the value of information related to these subjects, and you should try to uncomplicate this as much as possible. Now, let's talk about some of the highly tested issues. First, let's turn to corporations. Starting with the issue of fiduciary duties. The examiners love to test this issue, so it's definitely something to have on your radar. There are two fiduciary duties that apply to both officers and directors of a corporation, as well as members of an LLC. These two fiduciary duties are the duty of loyalty and the duty of care. Turning to the duty of care first. Whenever you see a duty of care issue, I urge you to also discuss the business judgment rule presumption. The law states that when directors make a business decision, that these directors have acted on an informed basis in good faith and with that honest belief that the action taken was in the best interests of the company. So the practical effect of this is that it makes whoever is complaining about the director's action carry the burden. It's usually a shareholder claiming that the director or officers did something wrong. So then, pursuant to the law, the shareholder would have the burden to overcome the business judgment rule presumption. Additionally, as it relates to the duty of care, keep in mind that we do not expect our directors and our officers to know everything. We allow them to rely on things like information and opinions, reports or statements of corporate officers, legal counsel, as well as public accountants. From a bar exam perspective, if you see the directors make a decision and they rely on information from someone else, make sure the person that they get that information from is the type of person that should be rendering that type of opinion or information. For example, if the directors are making a legal decision, the board can consult with a lawyer or rely on a lawyer's opinion in the making of that decision. This is because lawyers are professionals who can give legal advice. So this is reasonable for the directors to turn to someone like this for that type of opinion. Turning next to the duty of loyalty. The duty of loyalty is violated if a director is on both sides of a transaction, or if they compete with the corporation, or if they take a business opportunity. The biggest mistake we see students make on the bar is that they think the business judgment rule presumption also applies to the duty of loyalty, but it doesn't. Remember, the business judgment rule presumption only goes with the duty of care. So the most common way we see the duty of loyalty tested is an interested director or interested officer transaction. It's usually a situation where the director is on both sides of that transaction. When this happens, that's problematic because it looks like they're working with their own interests in mind and not necessarily working in the best interests of the corporation, which they should of course be doing, and therefore is likely a violation of their duty of loyalty. So when you see a duty of loyalty issue come up, you should see if any of the safe harbor protections apply. This is because oftentimes the question is also seeking if there is any way in which that officer or director can escape liability. Safe harbors protect or insulate directors from liability. These are when disinterested directors approve of the transaction after that interested director discloses their interest, plays no part in the vote, and discloses all information that's material to that issue. or there's approval by disinterested shareholders. Or lastly, if the transaction is established to have been fair to the corporation, judged according to the circumstances at the time of the commitment. So, if the fact pattern tells you that the officer or the director discloses their interest and there's still a majority vote in favor of that action, that means the director or the officer will escape liability for breaching their duty of loyalty to the corporation. Another highly tested issue are the different types of shareholder lawsuits. Remember, there are two types of lawsuits that a shareholder could potentially bring. If you're trying to figure out the difference between the two, ask yourself, what does the shareholder ultimately want? If the shareholder is trying to benefit themselves or trying to enforce their own rights, they should bring a direct lawsuit. This is because if they win, they're going to reap the benefits of winning due to the fact that the relief is going to flow to them. A derivative lawsuit is when a shareholder sues to enforce the rights of the corporation. So this means if they were to win that lawsuit, the benefit or the relief that's going to flow from that lawsuit is going to go to the corporation itself, not necessarily that shareholder who brought the cause of action. Oftentimes, when they test derivative lawsuits, they expect examinees to outline the requirements that must be met to successfully bring such an action. There are 3 requirements, and our mnemonic for this is SAD, S-A-D. The S stands for standing. This means the shareholder needs to be a shareholder of the corporation at the time of the complaint and injury and all the way through to the end of litigation. The A stands for adequacy, meaning they have to be able to adequately represent the interests of the corporation. And the D stands for demand. So they're supposed to make a written demand upon the directors, basically outlining their complaint and the relief that they want. The law requires that the shareholder wait 90 days after serving their demand before they file their complaint, but there are some exceptions to that. Turning to our highly tested issues within the world of LLCs. First things first, some people are concerned that they will not be able to tell if the essay is testing corporations or LLCs. One quick tip to know the difference is look at the vocab used. If you see the word shareholder used at all, then it's a corporations question. If they use the word member, then you know it's an LLC question. The highly tested issue we want to discuss is piercing of the LLC veil. Under the law, in order to prevail, the plaintiff must usually show that the members of the LLC abused their privilege of incorporating, and fairness requires holding them liable. Usually they do this by showing things like undercapitalization, the commingling of assets, or failing to follow formalities. Essentially, the goal of this claim is that plaintiff is trying to get around the LLC shield to hold the members responsible. Remember that for both corporations and LLCs, the law usually treats the entity as separate from the people who own and run them. This usually results in the people who own or run corporations and LLCs to be insulated from liability. This is why in some instances, a plaintiff can ask the court to set aside the corporate or LLC veil to be able to go after these individuals personally. Next, I want to give you another tip. To do well on a corporations or LLCs question, you should be aware of the basics. Many people struggle with this subject because they simply don't understand the basics. This is a problem because there are many nuanced rules within this subject, and they are incredibly difficult to understand and, of course, properly apply if you don't understand the basics. So it's helpful to have a big picture of how a corporation works, as well as the roles that the different players have. For example, the directors manage the corporation, whereas the shareholders are the owners of the corporation, and they're generally not running the business. They instead get their power by owning shares and voting. Officers are the agents of the corporation. They have the power to enter into transactions on behalf of the company. So again, it's helpful to have a big picture idea here of how corporations and LLCs work, the different roles that people play before trying to dive into those nuances. Another tip we have for you is to be aware of corporations and LLCs vocabulary. Many students report struggling with MEE questions because the question will use terms that they're unfamiliar with. This, of course, makes answering that question extra challenging. So to avoid this situation, much like my previous tip, spend some time getting familiar with the vocabulary before trying to answer questions. You will feel more confident in approaching the subject, and of course, it will make answering those questions much easier. The guide outlines some vocabulary that we think you should be aware of. Finally, be sure to set aside time to practice. Knowing the law is great, but knowing the law is not enough. You need to practice application of the law. And by practicing, you're also going to get familiar with how the examiners like to test certain issues. So that wraps up our discussion of corporations and LLCs as part of our highly tested issues guide.